After the Indiana General Assembly's week-long pause amid security concerns, lawmakers were back at the State House this week. A priority for the Republican majority is passing COVID-19 liability protections for businesses. It's a move many states have considered and pro-business groups support. The Senate took the first step, passing a version of the bill yesterday, but as Brock Turner explains, some of the House version could severely limit the rights of essential workers.
David Bride and his family have been union workers for decades. He works for the city of Indianapolis, and his wife is a nurse. Remote work in their household was never in the cards.
The workers who put their lives on the line, like my wife, my grandson that works at the grocery store, a union employee, we have to always have a voice where we can say, hey, this is not safe.
Bride, his wife, and thousands of other essential workers have kept working in person since the pandemic began. Estimates from the United Way show more than half of Indiana's workers are considered essential. While some are able to work remotely, many, like Bride, don't have that luxury and are concerned about extending broad COVID-19 liability protections to employers. Bride, who also serves as the president of the Central Indiana AFL-CIO, says his employer, along with many others, are taking the proper precautions, but he knows that's not the case everywhere.
It's essential that if you are an essential worker, that you feel that your job, your employer is going to make sure that you're safe.
Experts have mixed feelings on how legislative language could affect workers and businesses across the state. The Senate bill, authored by veteran GOP lawmakers Mark Messmer, Eric Cook, and Liz Brown, would, among other things, prohibit civil tort cases that don't meet the gross negligence threshold. Jody Madeira, a professor at Indiana University's Maurer School of Law, says the legislature is free to constrain the types of harm about which you can sue. She says the Senate bill strikes a balance between competing interests.
This goes back to the fact that this doesn't prevent lawsuits altogether, right? Businesses will still have to defend and say, this is what we did that was reasonable.
But there could be unintended consequences.
So I do think it would have a chilling effect, particularly, plaintiffs themselves might think that they can't win the lawsuit, but lawyers might not take these sorts of suits.
Specifically, a cause for Madeira's concern are places like long-term care facilities that have been ravaged by the virus because of policies.
Those businesses or those organizations where people are not allowed in. So for example, if the nursing home or long-term residential care facility is sealed and you can't have visitors, it's going to be hard because no one knows how grandpa or grandma got COVID, right? Because no one sees grandpa or grandma and no one sees the nursing aides that come in or things like that. And really there, gross negligence will be premised on the sheer volume of cases that come up, and perhaps the investigations that state authorities would do, but one would have to file a Freedom of Information request to get access to that information.
Indiana has implemented facility-first policies throughout the coronavirus pandemic, which has led to disdain from caregivers. While a cadre of industry groups testified in favor of the bill, not everyone is on board. Neil Gath is an attorney that represents the Indiana AFL-CIO, a group that advocates for more than 50,000 Hoosier workers. He worries the bill sets the bar too high for the average worker and has even greater concerns with the House version of the bill. If passed, the House version would forbid courts from recognizing local, state, and federal mask mandates. Experts say the mandates could still be argued, but it would be more difficult for plaintiffs. Additionally, House language would require plaintiffs to find an Indiana or surrounding state physician to testify on their behalf. For Gath, this language places the needs of businesses over the rights of workers.
If someone followed the rules and did the proper precautions, we think they have an argument for immunity. If someone flouted the rules, didn't follow the precautions, why should they get immunity for their actions?
While Madeira supports most protections, she believes requiring physician testimony could create inconsistent rulings or even a cottage industry. Both she and Gath say courts will have to interpret how to apply whichever language is passed, and he has a hard time thinking about how to argue these cases for clients.
You'd have to show a very high standard of negligence or intentional conduct by significant evidence. So, it would be multiple high hurdles. You would have to have very certain facts, both medically and in terms of exposure and carelessness, in order to meet that kind of burden.
Bride understands the need to protect businesses, but grapples with how it affects.
So they're in these environments that are risky, and for you to take that away and basically say, I'm going to trust an employer to do everything possible it can do. I just don't agree with that.
He worries the legislature will side with businesses and ignore the rights of Hoosier workers.
This is not safe. If you put something in place where an employer doesn't have to worry about consequences of their actions, then that's not good for workers. And that's not good for Indiana.
Legislators and trade groups insist they're not trying to limit worker rights, rather shield businesses from burdensome lawsuits. More than a dozen states have already passed some type of COVID-19 liability protections. For Indiana Newsdesk, I'm Brock Turner.